Yes.
My lord, what the mention about hearing item falls in Turkey.
Ah,
What is human right commission? This letter I sent to the party here from Assam. So this morning they give me a call that they want to come and discuss in person.
you want to discuss?
Yes. So let it come up after some time.
Okay, should I release it from Potter?
It's up to your lordship, my lord. You can give it as part heart also.
But I almost finished everything. Huh? I was supposed to dictate the order today,
My lord, I understand that.
thereby directing them to pay the amount.
My lord.
Mr. Inti Longshore, the learned counsel appearing on behalf of the petitioner, submits that his client, that he wants to have that his client have requested that the matter be taken up on some other day in view of the development on account of an order being passed by the National Human Rights Commission.
My lord.
List this matter again on when?
After 2 weeks, my lord.
List this matter again on 22nd of September 2025, taking into account that this court would not be sitting in the Kohima bench. The matter is released from parted.
My lord,
Much of
my business may be conflicted.
You
I'm
and
for
the-
respondent number 8.
Responding.
Much of that.
Your Lordship, Your Lordship, may I be allowed to mention an urgent unlisted case?
Okay. You want to do it?
Much of it.
For motion, item number 1.
Yes, your lordship. Petition was filed by the petitioner in respect of the payment of his, the petitioner's husband has served state government for the last 25 years. And after his demise, the pension process was initiated. However, when the pension process was initiated, it was detected by the AG that at the time of the appointment, he was overreached by 1 month. And for that reason, his pension cannot be processed. And there's a numbers of communication made between the state respondents.
You have worked for 25 years.
Yes, my lord.
Then
Then the petitioner's husband has expired. On expiry, the petitioner has moved a pension. And when the pension process, everything was initiated. At the time when the file was proceeded to AG department, the AG has come to detect that there was an overreach of 1 month at the time of appointment. The husband's appointment.
yes, government. What will these people do? He retired. When did he die? When did he die?
2018.
Thank
Your
goodness.
Lordship, at this stage, I have no instructions. The notice will be issued, Your Lordship.
Yeah, heard issue notice making it returnable on how much time?
My lord, if the court permits.
No, them.
3
I'm
weeks, Your
in
Lordship.
favor of passing the order right now in your favor.
3 weeks.
How
Your
much?
Lordship. 3 weeks. Your Lordship.
Issue making returnable on 23rd of September 2025. Ms. So-and-so accepts notice on behalf of the respondent numbers 1 to 5 and 7. Where is Mr. Seki or Mr. Muzoi? Anybody? Here, Mr. Seki's junior, Miss So-and-so, Miss So-and-so, who is the junior counsel of Mr. J. Seki, accepts notice on behalf of the respondent number 6. Extra copies of the writ petition be furnished to the learned counsels who represents all the respondents during the course of the day The case of the petitioner herein is that the petitioner's husband rendered 25 years of service and thereupon expired in the year 2018. At the time of finalization of the pension papers, the respondent number 6 have raised an objection that the petitioner's husband, when appointed, was overaged by 1 month. Full stop. The husband of the petitioner thereupon had submitted various representations, but the respondent authorities have not taken any steps in that regard. It is under such circumstances the petitioner is constrained to approach this court by invoking the extraordinary jurisdiction. The learned counsel appearing on behalf of the petitioner submits that the petitioner husband expired in the year 2018 and 7 years have passed by, but there is no action being taken by the respondent authorities. Full stop. Taking into account the above, the respondents are directed to bring on record their stand by filing the affidavit. In the said affidavit, amongst others, the respondents shall also apprise this court as to whether the respondents had intimated during the lifetime of the husband of the petitioner about his age, about his appointment on being overaged. Full stop. The respondents shall also bring on record as to why the representations so submitted by the petitioner have not yet been considered.
Much better.
For motion, item number 2.
So, Mr. Counsel, all motions are yours only today.
My lord.
What is this?
Yes, my lord.
Suspension.
Yes, this is.
How many years?
Now it is almost 10 years. It was never been reviewed. And the subsistence allowance, neither the salary has been billed to the petitioner. And the petitioner has been accused in one criminal case, which is under trial before the trial court. But not the subsistence allowance has been provided despite of representation at one point of time, nor his suspension has been reviewed for more than about 10 years. So we are invoking the.
It is in violation of Ajay Chaudhary.
No,
Ajay Chaudhary's judgment.
no. I don't think that this violence because yeah, for review of the judge suspension, there is a clear violation. After every 6 months, the authority has to review the suspension.
Why?
Either do after facing the trial, otherwise.
Tell me why? Why is it required?
Yes, my lord, here, the accused has been charged on a criminal allegation.
Hmm.
All right.
Why the suspension has to be reviewed? To me.
Reviewed in the sense that the subsistence allowance part, my lord,
Hmm.
the petitioner is entitled to get the subsistence allowance,
Hmm.
but the subsistence allowance was never been paid also.
Hmm.
So my main intention in this petition before this honorable court is that the subsistence allowance has to be granted. That is the priority before this honorable court.
Yes, madam.
Let notice go at this stage, Your Lordship.
When are you taking up? It's a case of subsistence allowance.
Lordship.
How the petitioner will survive
Lordship, stand Lordship.
next
After
week?
2 weeks,
Next week, suspension.
Lordship.
How do you take care? This is a gross violation of Article 21. issue notice making it returnable on 18th of September 2025. Mr. Ms. Esme appears on behalf of all the respondents and accepts notice. Extra copies of the petition be served upon her during the course of the day. Why are two petitioners?
My lord, the petitioner number 2 was the dependent, that's why I've just wife.
Petitioner number 1 is alive,
Yes, my lord.
so we strike out petitioner number 2 unnecessary.
Yes, all right, if the by official order that.
The learned counsel appearing on behalf of the petitioner submits at the outset that the name of the petitioner number 2 has been wrongly included. And accordingly, the name of the petitioner number 2 be struck off. This court, having also perused the materials on record, is also of the opinion that the petitioner number 2 is not required to have been arraigned as a party in the instant proceedings. Accordingly, the name of the petitioner number 2 is struck off. Full stop. The case of the petitioner herein is that the petitioner was working as a carpenter in the PWD Housing Division, Dimapur. A criminal proceedings was filed against the petitioner. And in respect to which a GR case number 492/15 in connection with Dimapur West PS case PS FIR number 0117/2015 dated 4/7/2015 have been pending against the petitioner. On the basis of the petitioner having been involved in a criminal case, the petitioner has been put in the suspension on 9th of May 2016. It is further irrelevant to take note of that petitioner is presently not in any custody. Full stop. The further case of the petitioner that since the date of the petitioner having been suspended, the petitioner had not been paid his subsistence allowance, which the petitioner is entitled to as per his service conditions. And further, the continuation of the suspension in the manner in which it is continuation of a suspension is against the settled principles of law as held by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India through its secretary and another, reported in 2015 7 SCC 291. The learned counsel further submits that the continuation of a suspension without a review being conducted for the last 10 years is an infraction to Article 21 of the Constitution, and accordingly, the present case is a fit case wherein the suspension order should be set aside and appropriate directions be passed for payment of the subsistence allowance during the period of its suspension. Ms. Esme, appearing on behalf of the respondent, submits that she would obtain instructions and file the affidavit on or before the next date. First, taking into account the above, list accordingly.
For motion, item number 3.
Yes, what is this?
Please, my lordship.
Compassionate
I,
appointment. What happened?
I have not disclosed in my repetition. I have filed contempt and on
What?
11/8/2025, notice has been issued. However, as my lordship is well conversant, contempt is just limited, and looking at the arbitrary defiance and disregard of this honorable court's order, they may take more further steps. So this is just for they have proposed the direction where my lordship has directed the respondent to fill up to give appointment in 9 handyman posts. That also after 5 years and leaving out the 4 more vacancies. On that was to arise on 30. The vacancies were to arise, future vacancies that was to arise on 30/6/2025. This honorable court has directed, my lord, the last operative portion is on at paragraph 12, page 19, lordship. Actually, it starts from paragraph 10, lordship. The actual factual position as to how lordship has directed for appointment after 1 year.
So now you are challenging this communication dated
Yes, lordship.
27/6/2025.
Yes, 2 communications. And annexure G page 27. This was sent to the learned government advocate Sri Mosem Sa Longkumar. Their inability to appoint the petitioner because she is a female.
She's a,
Female,
where?
yes, my lord. This is for conversion of the handyman post to technical support staff and computer.
No, the grade four
Operator.
vacancy arising on 36 in the food supply department is the post of handyman.
Lordship, 1 month ahead of retirement.
Yes, who is paying? So you are now in fine health. When the matter was taken up there before, you were not good.
No, I was there, Lordship. Lordship, just one submission that the vacancies mentioned, which was arose on the retirement on 30th June, has not been filled up as yet, still vacant. And as per this communication letter, it said that since the post of handyman,
Handyman, they have mentioning of 36/2023.
36, yes, 2025.
No, see that? First 2 lines of that order annexure G.
That's a typing error, Your Lordship. The
This is not the
vacancies-
typing order, this is the original document.
This, the date 2023 is a typing error. It should be 25, Your Lordship.
Lordship, we submitted 1 month ahead, a reminder was submitted on 28/4/2025. Even after that,
No, madam, the question is only one thing. I make it very clear.
Lordship,
If there is no you are going to get as per serial number.
Lordship,
If you are in the serial number, then you will get it.
I am in the serial number, Lordship.
You are at serial number 10.
No. They are misleading this honorable court. That
No.
was already decided in the writ petition, and my lord will kindly see page 25. I'm annexing again. The same annexure that was produced before this honorable court in the previous writ petition.
Your Lordship,
My-
if I
My lord will
may,
kindly see one, already she has withdrawn. Only there was 2. 2 is still there, not yet appointed. 3, 4 already appointed. Then 5, only 2 and 5 were remaining before me. So the vacancy which was to arise, and I was at serial number 3. This was produced before this honorable court by the respondent themselves. List of compassionate applicants with effect from 2018 till date. Now, Lordship will see that I am at serial number 9, but since All others are gone, and there is only certain
Was
number.
this annexure E1 a part of the earlier proceedings?
Yes, yes, very much.
And
Oh,
they filed
everything.
it?
They filed it. It was they.
As per the last week petition,
Hmm.
the petitioner was standing at serial number 4.
Hmm.
But since this matter was listed, I asked the department for the latest consolidated meeting list, and this is what they provided via WhatsApp relationships.
In order to
This
deny.
this is in consonance to the OM of the compassionate appointment, where the list is maintained as per first death basis, date of death, not the date of application.
And my lord will kindly appreciate, like in any other cases of compassionate appointment, they are not following the 50% compassionate appointment. This is the problem. So my lord has already given off in the previous list 4 vacancies to be appointed, those two who were above me. And only the vacancy that
But why this is different from this?
they are doing like this.
Why annexure E1 is different
Yes,
from the?
I was not provided with the applications that were provided, but it may have happened that, Your Lordship, between then and now, applications must have come.
Okay,
Ah.
is it on what basis? The death?
As per this OM, Your Lordship.
The date of death of the person, no?
Yes. The first death
As
person-
regards the petitioner's father expired on, a husband expired on 16/10/2021.
21, yes. Your Lordship.
Okay, that is why.
Yes.
So the date of death precedes because
Yes,
of that.
yes.
Yes, madam, that is a problem which it is there. You see, what has happened is this, the date of death of these persons which are there or earlier, they may have filed later on, but if you see that office memorandum, it categorically says that, where is that office memorandum? If I remember correctly. Where is the office memorandum?
It's not annexed in the petition.
Oh,
I have here one copy.
yes, and give it to her and show that clause. The precedence will be only on the basis of date of death. Show that clause to her.
Lordship, here in the previous petition, if my lordship will remember, the respondents were not following the 50% vacancy in a year that arises in the department. They are not appointing. And my lord will kindly see now the new incumbents that has been added here, their date of death is 2009. Now it's already going to be from 19, 11, 20, 16 years. And my lord, in your wisdom, knows that a compassionate appointment is for immediate financial relief. What they are doing is they are keeping away all this compassionate
But madam, the question is we cannot selectively
lordship.
apply one part of the OM and one part of the OM not.
That is also the thing. But in the previous petition, lordship, these things have been considered, and my lord has after perusing the.
Now, that is okay, but these people have come into picture. Now.
In other sense, lordship, a person who did. This is like exactly in police department where the contempt is pending for nearly 4 years. Contempt is 3 years and 7 months. Now what they did is they included all the names that.
Anyway, we only issue a notice. You file an affidavit giving an undertaking that you are going to follow that ratio. That's all. Then we can close it. That we are going to follow the ratio of 50%.
How much
50
have
or
been
5%
appointed?
of 50%, no, but as per the ratio which is there, you are going to
Yeah.
follow it and appoint him when her turn comes. That's it.
Lordship,
But don't reject it.
Yes,
Always say that it is pending
yes.
because it has not yet finished. Her father died in the year, my husband died in the year 2021. Yes, as per the year, the seniority gets the select list, the list is dynamic.
Yes.
It keeps on changing as regards the death of the person concerned.
Yes.
The death is prior, then obviously that person gets a precedence.
Lordship, my humble one prayer.
Mm.
to be fair, Lordship, the respondent may place those, how many appointment has been made? Now they are saying 2009. From 2009, how many compassionate appointment has been made? As well as how many vacancies have arisen? Because the-
Understood, but that I can't change it now. You
Yeah.
want, we'll issue a notice, that's all.
Yes, Lordship.
Nothing more than that, but I'm asking him to, you see, the matter needs, these are things which require to be unnecessary contempt on all these things. Issue notice, making it returnable on, 6th of October, 2025. Mr. M. Long Kumar,
Yes, Your Honor.
appears on behalf of all the respondents and accepts notice. Extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that the respondent authorities have, in spite of the order passed by this court on 6/6/2024 in WPC number 174/2023, have disregarded her claim for appointment against the vacancies which has arisen as on 30/6/2025. It is the case of the petitioner that the respondent authorities have in spite of the judgment passed by this court, have issued a communication dated
12 May.
27th of June 2025, whereby intimating the petitioner, whereby information have been given to the petitioner that her name cannot be considered against the vacancies which arise as on 30/6/2025, as she is at serial number 10. Full stop. The respondents are directed to bring on record their stand as to when the petitioner can be accommodated in terms with the notification dated 17/9/2015, and further as to whether the ratio which is mandated in clause 4 of the said notification is duly complied with. List according.
Lordship, in the meantime, my lord,
The affidavit be filed on or before the next date.
Lordship, they want to convert the post into another.
They want to do from handyman to MTS.
That can also be done as per the office memorandum dated 25th February
They are
2024.
trying to do that.
No, that is another. These are the posts of computer operators and into higher grade,
No,
Lordship.
you are class 7 pass.
Class 7 pass, Lordship.
You cannot be anybody else other than grade 4.
Yes.
So therefore, the handyman post has to be MTS.
MTS.
Yes,
But they are converting that to a higher post. That is what I'm saying before this honorable court.
We'll see when the matter comes.
Page F. Obliged, Lordship.
For motion, item number 4.
Lordship, can this be clubbed up together with the content?
No, yes, you ask that court, whoever is taking up. Yes, Mr. Longchar, where are you? Your matter.
My pleasure, Lordship.
This is your matter. Okay, he wants to do it. No. Then we are safe. Not a complicated matter then. Yes, what is it? What
Lordship,
pension you are asking for?
Lordship, here the petitioner is an Assam Rifle personnel,
Hmm.
enrolled as Rifleman General Duty. Lordship, here, what happened is that, we have served a notice dated 27/5/2025 to all the respondent, enclosed with judgment and order CAV dated 14/5/2025. Lordship, however, here, particularly respondent number 5, that is the commandant, the commandant.
You retired? Or you were asked to leave the service?
Oh, he was dismissed, Lordship.
Dismissed?
Dismissed, Lordship.
On what ground?
Deserter, Lordship. Deserter.
Deserter.
Yes, Lordship.
Then how do you get the disability pension?
Lordship, this honorable court, Lordship, if you may please, I may take you to Lordship, page number 29, Your Lordship.
Hmm.
26, sorry, Lordship, 26. But 27, Lordship, page 27, para 29, there is third line, Lordship. Page 27, para 29.
Hmm.
Third line, if I may be allowed to read, Lordship.
What was this case? Era?
Lordship, he was dismissed by impugn dismissal order dated 17/12/2019. Lordship, may kindly refer to para 2, page 3 of merit petition, Lordship.
But you are not challenging the court of inquiry. I'm challenging the decision where you have been held to be a deserter.
Yes, Lordship.
Where
Lordship,
the
it has been,
respondent should not be directed to pay in the alternative, pay a PNL as so and so and so and so. Where is your prayer that these decisions which have been taken,
Lordship, it's page 27, para 29, Lordship.
page 27, para 29.
Hmm.
Is it the same person?
Yes, Lordship.
Oh. You
Was it-
put
am I
so
allowed
many
to read that?
numbers out there, that is the problem. Ah. Okay, in view of this, the petitioner shall give in view of this. Now, what has happened after this judgment?
Lordship, we have served the notice along endorsed with annexed with this court judgment in order.
So the dismissal order has been set aside.
Yes, Lordship.
So therefore, you are entitled to this. Have you filed an appeal against that? You have not filed any appeal against this judgment.
Although we are intending to file an appeal.
File an appeal.
Yes.
Because without filing an appeal, you have a difficulty. The 3 months have already gone.
Yes, my lord.
Then, okay, issue notice making it returnable on 6th of October 2025. Yes. Good. Madam Langkumar will be there on that date. And so and so. Mr. G.N. Nagli appears and accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the writ petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner was dismissed from service as a deserter on the basis of a court of inquiry proceedings. This court, by the judgment and order dated 14/5/2025 in WPC number 71/2024, along with WPC number 314/2023, had set aside the said court of inquiry, and consequently the dismissal order of the petitioner had been set aside. The petitioner thereupon sought for, have issued legal notices for payment of his dues. However, the respondents have not paid, and it is under such circumstances the present petition has been filed. The respondents are directed to bring on record their stand by filing the affidavit on or before the next date.
Much obliged. From the supplementary cost list for unlisted motion, item number 17.
Your Lordship.
Hmm.
Your Lordship, this matter is relating to unjust suspension of students from the government higher secondary school.
Unjust
Unjust-
suspension
Yes, unjust suspension of students.
of
from-
student.
Students, two students,
Who has suspended you?
the principal, the school.
Why?
Because on 8th of August, petition number 3, he delivered a speech in the assembly on the topic punctuality and cooperation between students and teachers, highlighting that it would be good for the school and the students that teachers as well as students who are not coming to classes in time should maintain punctuality for the betterment of school. And then later on the same day, petitioner number 4, who is the captain of the school, was publicly scolded by one.
Madam, where is the suspension order?
Suspension order is in annexure 6, page number 22.
Where? No, these are appeal. Where is the suspension order?
Annexure 6,
Annexes, okay.
page number 22.
To your letters regarding suspension of here, we'd like to reaffirm the suspension order remains in effect due to serious nature. Their behavior was not limited to delivering a speech without permission on teachers' punctuality in the morning assembly, but extended to instigate and defaming certain teachers on social media, which went viral. However, considering that their learning stage and with the aim of providing a corrective opportunity, the school will allow both to continue. They'll be reinstated on so and so. We hope that this action will help restore discipline. Then
May I continue, Your Lordship?
you've got a very bad judge today. You should have moved it next week. I'm going to dismiss your petition. This is not done. Why on earth this court should exercise 226? Got better things to do. You have been defaming those teachers before and that too in the social media. And the school have taken action and have allowed you to join on 11th of September. Why on earth should this court exercise 226?
May I, Your Lordship?
Hmm.
Your Lordship, today is the last day of school working day. And for Monday, we have our exam, midterm exams. So the suspension is from 11th of August till 11th of September. And I will
This is a
give
school,
two papers.
however, you permit him to appear in that.
Yes, in fact, your lordship,
I will only record that you are not insisting on this suspension or
Yes.
anything, but
Allow us to.
only it's like a mercy plea that they should be permitted to appear in the exam.
Correct.
And he has no objection.
Yes.
That's all.
To be precise, your lordship, there is no suspension order. They themselves are admitting the petition that it is oral. It is oral.
No, only that. On a mercy plea, and they accepting it,
Yes.
allowing you to appear in the exam.
Correct.
When the exam is there. Exam
Starts from 9.
Monday, the 11th.
Monday is 8.
Yes, Monday.
11th.
Tuesday, Monday is 8.
Monday is not there, Tuesday.
Tuesday, yes. Monday is 8.
You are class 11, 12.
12.
Class 12, English you have. Okay. The petitioner herein have approached this court challenging the order of suspension dated 25/8/2025, whereby the petitioners, whereby the petitioner number 3 and 4,
3 and 4.
3 and 4 have been suspended till 11th of September 2025. First, the learned counsel appearing on behalf of the petitioner submits that the petitioners would not like to say anything on the cause, on the decision as regards the suspension of the petitioner number 3 and 4. However, the learned counsel drawing the attention of this court to the time schedule of the examinations, which is Annexus 7 to the writ petition, submitted that as the suspension has been up till 11th of September 2025, the petitioners herein 3 and 4 shall be deprived of appearing in the examinations which are to be held on 9/9/2025 and 10/9/2025. Mr. N. Angami, the learned counsel appearing on behalf of the state respondent, submits that the reason for which the petitioner number 3 and 4 has been suspended appears to be proper. He, however, submitted that the students, whatever may be, should not be deprived of appearing in the examination. Taking into account the above submissions, this clause closes the instant writ petition without interfering with the suspension order dated 25/8/2025, but directing the respondent number
5, my lord.
5 to permit the petitioner number 3 and 4 to appear in the examinations which are to be held from 9/9/2025 onwards. Mr. N. Angami, the learned counsel who represents all the respondents, shall duly intimate the present order to the respondent number 5 for due action.
Take it over.
Yes.
With the above, writ petition stands disposed.
For admission, item number 5.
Mr. Lordship, as per your last order dated 9/8/2025, the petitioner approached the Joint Secretary on 1st September 2025, and the petitioner was directed that
Oh, have you got the money?
yes, Lordship.
See? Then nothing remains, we close it.
Yes.
Huh?
Yes.
The counsel appearing on behalf of the petitioner submits that the petitioner had already been issued the PPO and also the payment as also the pensions and also have been duly intimated that the pension and other pensionary entitlements would be given to the petitioner. Taking into account the above, the petitioner therefore submits that the writ petition can be closed. Mr. N. Angami, appearing on behalf of the state respondent, submits, 1 to 4, submits that that as the petitioner number 2, who is entitled to?
Petitioner number 1.
Petitioner number 1 is a lady. Petitioner number 2,
Yes.
son has been given, not the wife. As the petitioner number 2 is entitled to the dues, the same shall be duly provided in view of the issuance of the PPO, taking into account
Petition number
1.
yes, now he's major. Earlier, he was minor. During the pendency of the petition. he is
But
major.
but the petition has been filed by some
The uncle.
whoever.
2 minors.
Okay. Okay. Petitioner number 1. No. Now, it has been given in the name of Joel Santan. Okay. Petition number 1, Taking into account the above, the writ petition stands closed.
For admission, item number 7.
Please, Lordship, the petitioner and the state council said court from to Lordship.
You have filed affidavit.
Lordship, I've received the affidavit filed by the state this morning. I filed my, I'm for respondent number 5, Lordship.
What does the respondent number 5 has to do? Where is
Lordship,
the petitioner?
the petitioner are challenging my point on
Land ownership basis.
Lordship.
You are there. You want to file reply?
No, my lord. No, my lord.
Then we finish it up.
Lordship.
Okay. Okay, what is your case?
I'm praying for appointment of MTS post on land ownership appointment. Seems no member from the landowner's family have availed the benefits of land ownership.
And they appointed respondent number 5
Yes, my lord.
without any selection process.
Yes, my lord.
And respondent number 5 has been appointed on the basis of what? Approval.
Approval of the government, my lord.
And the government does whatever they feel like. Yes, Mr. V. Zimomi. What is your stand? The petitioner seems to be very happy with your stand. He even doesn't want to file a reply. Yes, Mr. V. Zimomi, what do you have to say?
Lordship,
Page 7 is page 7 annex A.
Hmm?
This is the verification
Page 7.
Page 7 of annexure A. This annexure A, page 7 of affidavit in opposition lodging.
Ah.
Here, there will be
Of so and so, with reference to, I am directed to forward you with the application along with recommendation by the so and so. You are hereby required to verify the genuineness of the claim strictly in terms with so and so and so and so. It is pertinent to the one of the applicants, Longo Konak, has claimed that the family had donated in question way back in 1955. An oral agreement was made with the government. Fact is attained in the statehood in 1963. Therefore, while considering the matter, this should be ponder. Verification in inviting response to the have the unfulfilled the verification on the genuine landowner for appointment under so and so boy received from the employer of so and so so. Genuine in inviting reference of so and so boy was undertaken in received the verification long left. The applicant is not a landowner of a boy village land or so and so quarter land. The supporting landowner certification which was earlier furnished by Downtown Village Council dated 23 was cancelled by the council through the subsequent lender with clarification that the earlier supporting sheet was found to be wrong. So, Mr. Council, that is wrong. You have finished.
No, my lord,
Ah.
page 10 of the affidavit in opposition filed by the government.
Yeah.
It is clearly mentioned that the land belongs to me.
How
And
do you
no-
say?
And no appointment has
Other
been made
spot
on
verification
land-
and land management of the Iman and
on the
undertaken by
30th.
DB reported that the land where the SDO office building stands bearing a small portion area was donated by Longlo in appearing Longlo Laka and so was donated by so and so. You belong to, you are Konyak.
Yes, my lord.
So how do you get it?
The office land is donated by announcing village, and the individual landowner is my grand uncle, and the government have clearly stated that I'm the landowner
Where?
on page 4, on paragraph 4, page 10 of the affidavit in opposition.
Has reported that there is no formal land agreement record available in his office as to the area of Iman. The SDO officer is a permit issued by land permit holder so and so. Where?
On page 10 of the affidavit in opposition filed by the government.
Which?
Page 10, under the
This is the verification report.
It was 3H Lulu.
This is the verification report. which was-
Read it, read it, read it.
The applicant is the grandson, in respect of 3 Lulu, who is the petitioner.
The applicant is the grandson.
Or the elder brother of Ted Langkai, the actual landowner of SDO.
But the petitioner name is some Konyak. The petitioner has no land.
My lord, the actual land ownership, he could not apply for the land ownership, he had endorsed me, since I'm the relative.
Oh, not
of the
possible.
petitioner.
That is not possible. Is it possible? Mr. V. Jimomi, is it possible? Landowner means landowner who has given. Here that verification, am I wrong? The petitioner is one Mr. Konyak. We have not read the file.
Long connect. Lordship.
So here in this verification report categorically says that the petitioner is the applicant is not a landowner.
Lordship,
Am I wrong? In reading the verification report.
Lordship, if by the verification report, basing on the finding, here is clear, here is mentioned, basing on the finding from the accounting and report, the following conclusion are being made. In respect of Sri T. Longai Connect.
Now who is he?
Now,
No, who is he, Mr. Jimomi?
he is also, he is one of the applicant lords.
No, he is the petitioner.
And the petitioner is number 2.
No.
Sri H. Longo.
Oh, Longgong Konyak.
Yes, Lord.
Okay.
Is the number 2, serial number 2. In respect of Sri H.
H. Longo.
Lord. The applicant is a grandson of Yenu, who is reported to be the elder brother of late Langkai, the actual landowner of SDO Aboy office building land. The applicant's request for appointment to the post of MTS is based on this relationship with the actual landowner, which has been endorsed by Nangching Village Council, Lordship. So Lordship, the applicant, the petitioner is the landowner.
So he had a right to be considered. And
Lordship,
did you
as far-
consider it?
As far as the verification report is concerned, Lordship.
Now, did you consider it? This is the verification given by the deputy commissioner, means this is a verification given under 3A.
Lordship,
So therefore, you were required to consider his case. Did you consider it? Answer is yes or no? No.
Lordship, one,
You have appointed somebody.
Lordship, we have appointed someone.
Whom have you appointed?
We appointed the private respondent.
Is there a stay?
No.
Huh? No. Okay,
If I may, Lordship.
please.
Lordship, after having the information that the vacancy of the post in question has arisen, the respondent number 5 submitted an application to the government. And the applicant received percent to the government for selection and approval, and through selection process only, I was appointed, Lordship.
Huh? No, through selection is okay, but he filed an application. That application has not been taken into consideration. Huh? Without considering his application, can you do so? Mr. V. Zimomi? Can you do so? So what should I do? This is another case, new type of case. Where the government now admits that he is a landowner. An appointment, however, has been made by following the due process.
Lordship.
Should this court exercise the writ jurisdiction? Does the right for appointment on landowner supersedes the right of selection? What does the notification dated 16/8/2008 say? What does it say? What? You have to help me out, Mr. What does it say? Does the notification dated 16/8/2020, 2018 says that the right of a landowner is higher than, first has to be considered, then the question of selection comes. Does it say that? Yes or no? You are not clear.
For this similar matter, we spoke by this honorable court in WBC 122 of 2023. Here, the private respondent appointed Moscow, and the court has directed the department to look into the application of the petitioner. Here, after I submitted my application, the department, the SGAO, has forwarded to the director, and the department is supposed to direct the deputy commissioner to go for the verification of my claim. But instead of going that process, the government has given the approval of appointing the private respondent. The case is very clear, and the state government affidavit has clearly stated that no MTS appointment has been made from the landowner. So there's no question of dispute here, my lord.
No,
And-
I'm not on that. The question is, I hope you have not understand, three of you. Whether is it the mandate of the notification dated 5/3/2018 or 16/8/2018 that the landowner person will have a preference than a regularly selected candidate?
Yes, my lord.
Where?
This case, it is disposed by the honorable court.
Show me that. Does it say so?
Yes, the 123.
Oh, this is a different case.
No, landowners, yes, landowners.
Understood. This is one case I understand. But here is a case. I decided against the landowner. I decided against the landowner. I decided against the respondent also. Isn't it? He was not the case out there. Here a submission was made, the preliminary objection was made, which was a suppression of material facts and all. Then I say that, okay, he may not be entitled to as per the land ownership, but he will be entitled as per, we set aside that. But this is not the question which I am saying. Here the stand of the respondent is very clear. Two things. You are the landowner, you have a right over landowner, but at the same time, the respondent number 5 has been properly selected. Now, therefore, my question is, does a right of a landowner supersedes the right of a selected candidate? That's my question. Yes or no, Mr. William? No. So you say that the right of a landowner is first to be taken, then comes selection. Hello? On the basis of that, we set aside your appointment.
No, Lordship.
Oh.
Lordship, here, my affidavit, page number 3, Lordship, paragraph 3.
I say.
The state of Nagaland came into existence only in 1963, whereas as per the petitioner's statement, the land in question was donated in the year 1955. Therefore, there could not have
So
been any.
therefore, why are you not saying that you want to file a reply to this? I asked you, are you going to file a reply? You say no. Does this affidavit of the government not go against you?
Lordship,
Why you are not filing a reply?
Lordship, I have received only this one, so if that is the case, then sometime may be granted, Lordship.
No. The counsel appearing on behalf of the respondent number 5 submits that the affidavit in opposition filed by the respondent state goes against their own stand, and more particularly when there was a direction to make verification based on the question as to whether there can be an oral agreement with the state when the state of Nagaland only was formed in the year 1963 and the oral agreement was in the year 1955. He therefore submits that he would like to file a reply to the affidavit in opposition filed by the state respondents. List this matter again on 8th of October 2025. Affidavit be filed by 6th of October 2025. Huh? No, he is going to file against your affidavit. Because your affidavit goes against him and your submission goes against him. He says that I am a regularly selected candidate properly. He must have thought that you are a respondent cannot file an affidavit against the respondent, so you did not. But that is permissible when it is a respondent stand goes against you. Because you have to also protect your rights.
The stand of the government is that also they kindly come to page 3 of my. Here it says that moreover the contention of the petitioner is that the alleged oral agreement was made in 1955, which is prior to the state to the against the petitioner lordship. When I say that, how can this private respondent?
No, when I was asking you what was your submission?
Lordship, that is clearly mentioned in
No, but Mr. Jimomi, have you read your brief properly? I have been asking you 4, 5 times, what is your stand? You are just keeping mum. What do I do? Tell me. Man, give me a good idea.
We are against the petitioner.
Because but you see, in your affidavit, equally, you also say that as regards the verification report,
Lordship, we are not denying.
you are not denying the verification report.
Lordship,
And on the other hand, you say that because of the pendency of the case, you don't want to say anything. Isn't it your statement in your affidavit?
that statement of ours.
I've seen it.
Lordship.
Then, see, kindly come to paragraph 5, the second paragraph.
Lordship, but. Lordship-
You have the brief with
I
you,
will
you
just
draft
exit
the
the petition.
affidavit, you don't
Lordship,
know.
important file against the government respondent when I say that
No, because of the fact that you say at paragraph number 5, see the subpara. See the subpara of paragraph 5. Read it.
that Lordship.
Then he has to oppose it. There are in many cases it is being done. In the CPC, there is, you see, normally a counterclaim is filed against whom? This is like a counterclaim, it becomes a counterclaim. Because you are going against him.
That is as per the verification of the ADC.
So therefore, why on earth did you not consider the case of the petitioner earlier? And want to give it and give it to him? So he has a right to file an appeal. Yeah. Or he has to file a writ petition. You see what you have stated. It is also to state herein that by letter dated so-and-so, government forwarded the case of the petitioner and another two individuals who are also landowners for verification to the Deputy Commissioner Mon in terms with the OM dated so-and-so. The Deputy Commissioner Mon submitted a verification report. Accordingly, by letter dated so-and-so, the department forwarded the verification report to the government for decision. However, by letter dated so-and-so, the observation of the Land Revenue Department states that the matter has been examined and it may be noted that the matter concerned as of now is sub judice, whereupon the department is advised to await the Honorable High Court's judgment and order for further necessary action. So this is what you are saying. So therefore, he has to challenge this verification date. How does he do it? He comes up and files an affidavit in that regard. Oh, 8th, 9th. We'll have it on 9th, huh?
Okay. For admission, item numbers 8 and 9.
That's Lordship. Lordship, I'm the petitioner in item 9, WBC 1-2, Lordship. Lordship, as per this court's direction, the respondents have filed an affidavit, additional affidavit, bringing on record the death of the father of the petitioner. But Lordship, if you see the annexure B, page 9 of the additional affidavit filed by the respondent, Lordship, as before, the death certificate is issued by the chairman of Telungre Village Council, Lordship. Lordship, here my submission is the village council is not an appropriate authority to issue such a death certificate, Lordship, except for the Department of
Who is
Economic
respondent number
Statistics.
4?
Lordship,
Medical name.
Lordship,
You have filed this.
yes, Lordship.
Saying
Saying that the Lordship, in the annexures of the petitioner, they have included 3 documents, which is the material record of the writ petition. There are different date of birth and then father's name. And then because of that, the private respondent has made a representation against all those irregularities. This is a false certificate. And then basing on that, the respondent has rejected my representation. So the higher authority, the private respondent has made a representation to the honorable to the minister concerned, who is the cabinet. And then accordingly, all this rectification was done, and then I was given the appointment. And then I'm saying that since the police authority, the administrative jurisdiction comes under the police authority, they have every right to certify every citizen that he's a bona fide citizen or the occurrence of any this and that event. So accordingly, this has been enclosed in my this representation. So despite of all this representation, we have.
you want to file a reply.
Lordship.
Mr. So-and-so appearing on behalf of the petitioner submits that in view of the additional affidavit filed by the respondent number 4, whereby a document have been enclosed at annexure number B, he would like to file an affidavit in that regard. List this matter again on 9th of October 2025. The affidavit be filed by 6th of October.
Lordship, I may be also allowed to file a affidavit in respect of the affidavit filed by the affidavit opposition filed by the respondents.
In addition to that, the learned counsel for the petitioner is further given the liberty to file the affidavit in reply on or before, in respect to the affidavit in opposition filed by the respondents on or before 6th of October 2025.
Have your pleasures.
For admission, item number 10.
Lordship, this honorable court was by order dated 29/8 has directed the respondent to file an affidavit. Lordship, I filed my affidavit, Lordship, yesterday.
Okay, I've asked the government to obtain instruction, madam. Hearing on behalf of the residents, so how many candidates applied for the vacancy in the establishment of the respondent and were there any selection proceedings? Mr. Muazumir, you are for the petitioner? Why he has now becoming taking the role of the petitioner? Received two applications, that is from the petitioner and the private respondent against one vacant post of so-and-so. The claim for appointment on however the landownership has exhausted claimant event is such. The department considered the private respondent eligible to be appointed regarding the private respondent. Department was okay. Private respondent name?
Yes, Lordship.
ODU, both are ODU. Then the other is Wong Dong Benny is private respondent or he is BA pass.
They were only two applicants, Lordship.
And he got the recommendation from the Deputy Chief Minister. You got the recommendation from the MLA. You see? The question is who is more powerful? Then he got also another recommendation from an NCS retired MLA forwarded by the CMO Waka, NOC by the chairman and secretary Bhandari town owners there. That case, Mr. Moa, Jamil, not interfere. There were only two applicants. You see, I would have otherwise any other person would have come, I would have said. But you are the person who had participated. You have lesser educational qualification than him. Then okay, and I would not say much on the power of the recommendations. But when there were two and you did not meet, yes, if you had a better educational qualification, then question would have been different. He's a BA pass, you are class 12. Hello.
My respectful submission would be if your lordship may consider this instant case in the line with the earlier order which was passed by this honorable court. Or 27/8 lordship, similar case lordship.
Huh? Yes, I know this, but this is a case where there were 7 applicants.
Yes, lordship.
Here we have only 2. Then how do I help you? And this is not that lady who has argued, it was never her case. The other side also only was arguing, and because of that, she won the case. Yeah. No case. Now I think we should dismiss. Okay. Heard Mr. Muajami, the learned counsel appearing on behalf of the petitioner, Ms. S. Siang, the learned government advocate, who appears on behalf of the respondent numbers 1 and 2, and Mr. So-and-so, the learned counsel, who appears on behalf of respondent number 3. This court had passed an order on 29/8/2025. Whereby instructions were sought from Ms. S. Sang, the learned government advocate, as to how many candidates applied for the vacant post in the establishment of the Chief Medical Officer WOCA, and was there any selection proceedings in that regard? And further, what was the basis on which the respondent number 3 had been given the appointment? Today, Ms. S. Sang, the learned counsel, appearing on behalf of the state respondent, placed before this court a set of instructions which are kept on record and marked with the letter X. Footstop. In the backdrop of the above, this court now would deal with the facts which led to the filing of the instant writ petition. The case of the petitioner herein is that the petitioner predecessor family had donated certain land and claimed appointment on land ownership basis in view of the notifications issued by the government dated 5/3/2018 and 16/8/2018. Full-stop. The petitioner further was aggrieved by the appointment of the respondent number 3. Full-stop. From the affidavit in opposition which was filed by the respondents state, it was apparent that the petitioner herein was not entitled to claim on the basis of land ownership. It is under such circumstances when the matter was taken up on 29/8/2025, Mr. Muazzami, the learned counsel appearing on behalf of the petitioner, have contested the appointment of the respondent number 5 on the ground of violation of Article 14 and 16(1) of the Constitution. This court duly takes note in the above perspective. Now this court would like to take note of the instructions which were placed by Ms. S. Sang and kept on record and marked with the letter X. From the said documents, it would be seen that there were only 2 applicants who have participated, and on the basis thereof, as the petitioner did amongst the 2 applicants, the petitioner claimed appointment on land ownership basis. However, the petitioner's claim for land ownership basis was not in terms with the standing extent law. It is further mentioned in those instructions that thereupon both the candidates were the respondents have carried out a selection amongst both the candidates who have submitted the applications, and it was found that the respondent number 3 had better educational qualifications, and accordingly the respondent number 3 was selected and accordingly sent to the government for approval. The government thereupon granted the approval, and on the basis of which have granted the approval. Full stop. This court, having perused the materials and more particularly the documents which are kept on record and marked with the letter X, do not find that there has been any violation of Article 14 and 16 of the petitioner. And accordingly, it is the opinion of this court that the present writ petition lacks merit, for which the writ petition stands dismissed.
For admission, item number 11.
Your Lordship, we have just received the affidavit filed by the government this morning, Your Lordship.
Yeah, after I came, the governments are now filing affidavit.
Just kindly give us some time to go through the.
Okay, the counsel appearing on behalf of the petitioner submits that the affidavit in opposition of both the state respondent as well as the private respondent have been received only today. Full stop. Taking into account the above, the learned counsel for the petitioner submits that she would like to obtain instruction as to whether the petitioner would like to file any reply. Full stop. Taking into account the above, leaves this matter on 13th of October. Full stop. The affidavit, the petitioners herein are directed to the petitioner herein is given the liberty to file his reply on or before 8th of October by giving advance copy to the counsels appearing on behalf of the respondents. So and so and so and so appears on behalf of the respondents.
From the supplementary cost list for admission, item number 15.
Yes, what is this?
For non-payment of security.
Huh?
As per the order dated 1/9/2025.
Oh, yes,
to
yes,
get this.
yes. Oh, this one. Yes, I asked you. Instruction. Again on 4/9. Yesterday, that matter came up, no? Okay. Online. With and reference the located demand and like the set of which they have already been intimated and we have submitted required for the local of the compiling and the get what the case of the still of the certain persons. No, this cannot happen.
Your lordship, along with
This is a very serious thing.
Your lordship.
Then let the government give an undertaking, they will pay interest.
Your
Now,
lordship,
first of all,
Yes.
are you therefore submitted? You duly admit that these are cases of very minor technical mistakes. The petitioners were duly informed, petitioners submitted those documents, and then you are waiting for the PNR to give a clearance. Now, are you therefore suggesting that the petitioners who are now in the government employment should abuse their powers and resort to taking bribes and all? Otherwise, how on earth the petitioners would survive?
Your lordship, I will also be able to make a submission. Your lordship.
We can
On
also
the
pass
last-
another order that there should not be any, there should be a freezing of all payments to the government advocates for 5 years. How will you like? This is something. It is on minor mistakes you are withholding. Now, who will be responsible to pay for the amount? Well, I asked them. Now.
Your lordship, that's why.
We'll ask if
we will be allowed to make a
the
submission.
payment be made from all the interest, they will take loan, you take loan, we give you the liberty to take loans.
Your lordship.
And any interest which you are is to be paid by the engineer, PI in or out.
Your
This
lordship.
cannot happen.
I understand your lordship, but your lordship, I may be allowed to make a submission, your lordship. On the last occasion, I had placed one instruction to your lordship. Along with the instruction, I would like to make one submission.
What is that instruction? I remember the instruction. Tell me,
Your lordship.
which I could not see it with my
The
naked eye.
The instruction, there was one annexure, your lordship. I would like to read that. Your lordship, as far as this case is concerned, your lordship, the respondents which were impleaded, your lordship, they have played their part, your lordship, they have done everything that they have, your lordship. It's not like the matter is kept in cold storage, lordship. It's an ongoing process, your lordship. And your lordship, I also like to place.
But you don't have R1 here. Where do you bring in R1? Tell me. Where is R1?
Your lordship, that's why your lordship, I make a prayer that PNR may be included, your lordship, and for proper adjudication of this case, your lordship, PNR department would be important, your lordship, because right now the matter is lying with the PNR department.
The Supreme Court has
So-
stated that the government should speak in one voice. How are we concerned?
Because now the matter is with the PNR. So
Get
we'll
your-
know the- we'll
get-
know the latest status.
we will-
and-
we-
and
we
give you
will-
The latest status.
We will have it at 2 o'clock when I think when one matter Advocate General is hearing, we'll ask him. And when the Advocate General says that things will be done, we'll have it at 2. Take it up at 2.
Your lordship, right now, we just want to know that.
No,
the
please
latest
take it,
status,
no,
your lordship.
madam, this is, otherwise, let the government give a OM, because the government of Nagaland has the habit of giving OM, that in the meantime, till we do all this, I'm not saying about do anything for N or R2. I'm not saying. They fall in R1. They have given all the testaments or document. Now, keeping it for last 4 years pending before them, this is not done. How will these people survive? Give us a good solution to that they can take loan and the government will pay the interest. Better. We'll take it up at 2. Because the Advocate General is appearing in one matter, so I'll ask him, let the government come up with an OM that we will allow all these loans. And when the Advocate General says it will be taken as the state has stated. But this cannot go on, madam. I see the additional Advocate General there. Ask her. She can also represent all departments. You may have some problems, but she would not, because she is considered to be she can also appear for everybody. Like her status is that of a senior government advocate. But this is not done. We cannot allow such things.
Your lordship, and also I'd like to,
Madam, just give me how will these people survive for 4 years? Tell me.
yes, your lordship, I understand your concern.
Then-
Your lordship, but.
No,
your
not
lordship,
my concern, but
Then-
it is the sad thing.
Though it says it's a minor clerical error.
Yes,
but-
yes, additional Advocate General. Why don't the government of Nagaland issue an OM? That look here, those people whom we are not giving the salaries, we will give them salaries. In the meantime, they can take loans, and we are also going to bear the interest. No, because 4 years you can't keep on minor clerical mistakes them. And when they have duly submitted, and the PNR is just sitting on it. Can it be possible? How will these people survive? Unless the government may give a declaration that they may resort to taking steps which may not be a constitutional manner and take money for their survival and livelihood. If your government does either of it, it would be better. From March 2021, these people have not been paid on the ground that their father's name was not properly mentioned. It is not as per the Aadhaar card. They thereupon submit all these documents, and the government the department have already sent it. PNR is sitting on it. It cannot happen like that. 4 years, how will they survive?
But if it is a sanction post, then PIMS will be there. But if it's not a sanction post, then
It is all in sanction post. There's no quarrel with that. They
He's a
have
fixed
not
pay.
given the salary from
it's
there.
a fixed pay. So when he's a fixed pay,
Are you in
that's the
fixed
question
pay?
comes.
Then fixed pay, then whatever may be, fixed pay you have, are you not taking his services?
Yes, for that matter, too, for the fixed pay too, only if he provided all the necessary documents.
He has already done. There is no quarrel. He has not done. And it was not found anything very serious. It was found that the father's name did not match with the Aadhaar card.
Lordship, I've been told that he has changed his name. he has changed his name, so the legal name change has to be.
No, no, his
inserted
father's name did not match.
Name.
Now, there are 6 petitioners.
They were all appointed by a common order. There
Hmm.
are 6, however, 2 of them are getting their monthly salary. 4 of them. Since March 21 till date.
They have not got.
No, no.
Yeah. And no, madam, I would have understood if you have kept him in category R2 or N. You are not. You categorically say in your instructions that they come under R1.
Then, Lordship, he has not made the PNR as a party respondent in the present petition.
That is why I have got the additional advocate general. You don't require the PNR because of the additional advocate general. You cannot
Then,
do this.
Lordship,
And therefore, I'm saying, they do something for, okay, if you do want to take their services, do it. But if you are taking their services, then if you don't pay, how will they survive?
the Lordship, based on that instruction.
Or come up with another office memorandum that for 4 years, as we have not paid, we'll regularize their service. A person who have not been paid, how will he afford to make another copy and implement PNR?
Lordship, in the OEM or the instruction which my learned friend has submitted, it's very clear says that during the verification process, they are directed not to report for duty.
You're not reporting from duty.
Lordship, I'm still serving.
Then,
So how can your Lordship?
I take instruction.
Clearly says that. That
first of all, in your OM, there is no R1 category.
Well, for that matter, Lordship, sometime may be given to.
I've given lots
instruction
of
from the
time.
PNR. You have given time, Lordship.
Then how much time do you require? Leho. It has been submitted by Ms. B. Suproy, the learned additional advocate general, that from the instructions it appears that the matter that the issue on non-release of the salary of the petitioners is on account of the matter being pending before the PNR department of the government of Nagaland. So, taking into account the above, this court therefore impledes the commissioner and secretary to the government of Nagaland PNR department, Kohima,
Yes.
Kohima, as the respondent number. What is the last of the respondent?
7.
No,
Till up to 6. So
respondent number 7. Pusto. The counsel appearing on behalf of the petitioner is directed to, you have a commissioner and secretary, na?
Yes, Commissioner.
Is directed to file a fresh memo of party before the registry of this court by Monday. And on the basis thereof, the learned, the registry shall make necessary correction of the etul line to liquidate. Full stop. Ms. V. Sikroy, the learned additional advocate general, submits that she would obtain instructions from the PNR department and newly implemented respondent number 7 as to why the amount, the verification is stuck with the state department. List this matter again on 12th of September 2025 for further update.
Oblige.
Have to already done.
Orang sih dalam macam buat sekarang pula mau aku tak bisa. Ada kan? Itu body itu belum ada. Benar. Poison dan lagi ni kan kalau
With your lordship indulgence,
Hmm.
apparently the matters in the admission column is already exhausted. And my matter is the admission column but fixed at 2.
Okay, we'll take it now.
Yes, that's what we wanted to break. Lordship, on day before yesterday, your lordship was placed
I
in,
passed a long order.
yes, was placed to directly learned
Yeah.
vacancy of the operations.
Lordship,
These are the two aspects. One is whether prior to office memorandum of
Yes.
2015, which restricted granting of AR to those who have not completed certain year.
So your lordship here, now we have been using that, CSS pension roll 1972. Prior to that office memorandum 2015. So admittedly, that office memorandum 2015 cannot be applied in the present case. But CSS rule 1972, it was enforced. And lordship here, in order to substantiate that one in one coordinate bench, it was decided by his lordship, Mr. Sertu. Judgment order dated 23/2/2017 in WBC 3K of 2016. That in that particular case also, the court has clearly stated that CSS rule 1972 is in force. So in the paradigm, it is just to clarify the body of the important.
Mr. Imsong, I would advise you to put your instruction by way of an affidavit. There's a reason why I want an affidavit, because then it won't be a blame upon you.
Yes, yes.
I've clearly mentioned everything
Yeah, safer side.
because you'll be supporting the case of the petitioner, isn't it?
Mashallah.
So let it be done through an official,
Mashallah.
because you never know.
Yes. Then in that case, the time will be granted and this matter can be taken up by VC also, since it's already underway.
Substantially, it does
No,
not
only
hurt.
these two instructions have been asked for. So therefore, you file an affidavit because it would be helpful for you. And it would clear the situation for all times to come. And this will have some ramification on the financial aspect. So I think better let it be filed by way of an affidavit. And record it, that aspect.
Lordship, just before your lordship begin the decision, as of now, the state government apparently does not have any policy in this regard. So that could be.
No, that is what I'm recording. Mr. Inti Imshong, the learned additional advocate general, Nagaland, submitted with all fairness that prior to the office memorandum of with all fairness, that the CCS pension rules 1972 is applicable to all the employees of the state of Nagaland. He further submitted that there is no other office memorandum as per his instructions, whereby the period for grant of entitlement of invalid pension have been restricted prior to the office memorandum of 2015. On the second query, which was made by this court in its order, in the order dated 29/8/2025, the Learned Counsel, Learned Additional Advocate General further submitted that taking into account that it has been a pretty long period, it is only after a very long period the petitioner has approached this court. It is difficult to find out the records as to whether the petitioner had a pre-existing disease prior to entering into service. Also, taking into account the above, it is the opinion of this court that officer that the said queries so raised by this court by the order dated 29/8/2025 be answered by way of an affidavit, as that would help in the adjudication of the present dispute. List this matter again on how much time?
Later part of September, later part of this month.
List this matter again on 22nd of September 2020.
Second or 23rd?
22nd?
22nd or 23rd will be good.
23rd is if I have to take it, it will be a hearing day there. It's okay, no problem. But here also the judge can take it. Why should I take it? It is already-
Because substantial submissions already been made and your lordship is already apprised of the.
List the matter again on 22nd of September at 2 p.m.
Yes.
So stop. The counsels appearing on behalf of both the parties have submitted that as the matter had been substantially heard on the earlier occasions, the matter be shown as part heard. Next, this court would be holding the roster in the principal seat. And I will, as I would be holding the roster in the principal seat, comma, the registry is directed to list the present matter in the principal seat on 22nd of September at 2 p.m. As 23rd of September at 2 p.m. And instant with petition would be taken up for further hearing on the said date through the video conferencing link to be provided to both the parties. First list accordingly.
Lordship, I just want, if necessary, I may be allowed to file.
In the meantime, the petitioner would also be at liberty to file any further pleadings.
Much obliged.
Now, I am doing it only for the purpose that for later on, it does not become the ground of appeal.
Lordship.
After all, at the end of the day, the person has to, it would be very difficult for him to sustain the finances for an appeal.
Much obliged for the concern.
Finished?
For hearing, item number 16.
Lordship, as per the last occasion on 29 August, I was directed to get instruction as to whether any selection process was held for the appointment. Now, Your Lordship, the department has informed me that they had received about 4 or 5 applications, but they can't ascertain how much, and they wanted some more time to provide those documents. That is what I was instructed.
Please, Your Lordship. Your Lordship, the said respondent has not even called for the advertisement, as they have already said in the. But no,
No,
Lordship,
for
on
you,
the
you
last-
have participated.
No, Lordship, no.
They have also,
I have not
yes, they have also submitted your application.
No, you
They have
submitted the application, huh?
Yes, we have.
So you were,
submitted.
the question is whether you were considered. If you are not given on the basis of land ownership basis, whether you were considered on the other aspect, that is the question.
Yes.
If you are considered as a non-land ownership basis also, then it is okay. But if you are not considered, then obviously it is bad.
Lordship, in the meantime, on the last occasion when the matter was come for hearing, as you mentioned, Lordship, I've gone through the
Yeah.
FBC 132 of 2022.
Everybody now is having that journey. It's okay, I know that. Now I ask you, that this is an important thing which will be helpful when this matter is taken up again.
Yes.
I may not be taking up, but okay, Mr. M. Longkumar, the learned counsel appearing on behalf of the respondent state submitted that pursuant to the order passed by this court on 29/8/2025, certain verifications have been carried out by the respondent state as to how many applicants have participated, were considered for filling up the post of
MTS.
MTS at
RD block different is.
RD
RD block.
Rural Development Block different.
so and so. He, however, submitted that this verification would take some time and as such sought for some some accommodation so that the said aspect can be brought by on record by way of an affidavit. He further submitted as to whether the petitioner was duly considered. Would also be brought to the notice of this court by way of the affidavit. List the matter when?
2 weeks, Your Lordship.
List the matter on 22nd or 25th of September 2025.
Lordship.
The affidavit be filed by 22nd of September by the state respondents, along with the record, and the records also be produced.
Obliged, Your Lordship.
Only one matter.
itu tuh kayak ayat apa? Saya telan.
For pronouncement of judgment, item number 1. The detention order dated 8/4/2025 with regard to detaining Abdul Ali and other consequential orders, also the approval order and confirmation order dated 10/7/2025 are set aside. The records should be returned to you. Oblige, my lord.
Records. Records is been given to me.
Just get it.
If this will my sincere apology in the supplementary help, I didn't see. Interim. Interim will be continued.
Oh, that interim, I've not signed. If I've not signed it, interim continue that, huh? The last item number 16. Okay.
For orders, item number 1.
Yes, what is this? Have you filed the affidavits? Government? Respondent number 1 to 10 are given the final opportunity to file the affidavit. However, the respondent have not filed the affidavit. Then?
Would require some time, my lord.
What some time?
My lord, we're still in vetting process, my lord.
Does it take years for you to file affidavits?
My lord, because it's still in
So
vetting
it is a
process.
practice out there in Itanagar that you file your affidavit whenever you feel like. Should we call the officials out there, who are those people, why they have not filed the affidavit? I think we should ask for a personal appearance. Who are this? Current has gone. Where is? 1 to 10. Yes, who is appearing for this Gauhati High Court?
My lord, I am my lord. I'm representing, I'm appearing on behalf of M. Pertin, senior advocate, my lord.
Who? Gauhati
M.
High Court is the standing counsel, Itanagar bench.
Yes, my lord.
Who is it? Mr.
M.
Mukta
Pertin.
Patil.
Yes, sir. He's the
That's
honor.
such a long time. Okay. It is seen that the respondents, in spite of opportunities being given on various occasions, have not filed the affidavit. Considering the above, comma, this court fixes this matter again on 18th of September 2025, on which date the matter would be taken up for disposal on the basis of all materials already available on record. Full stop. The my goodness. There shall be further no opportunity be granted to the respondents to file any affidavit, inasmuch as for a period of more than 3 years, the respondents have failed to file any affidavit.
May I, my lord? May I, my lord? My lord, I am appearing on behalf of respondent number 11, my lord. This is my first
Why
appearance.
haven't you filed the affidavit?
My lord, I need at least 1 week's time to file affidavit, my lord.
Why should we give you time to file affidavit?
My lord, this is my first appearance, my lord, on behalf of respondent number 11, my lord.
So what?
It is only after service of notice, my lord, I am appearing for the first time.
And this is for 1 to 10 shall not be given any further opportunity to file affidavit. However, the respondent number 11 is given a final opportunity to file the affidavit on or before the next date. Final opportunity.
My lord.
Obliged.
Much obliged.
For hearing, item number 14.
Sorry, when I had to appear on VC. There were other matters.
No problem. No
Courts.
problem. First of all, you say, this is a matter, Mr. Advocate General, this is a matter which is going on account of a child who had developed some ailment at the time of his birth, and thereupon the Christian Medical Hospital Institute initially said that this particular ailment of the child cannot be treated in Northeast, for which the matter went to the AIMS for an opinion. AIMS gave an opinion that it can be still continued out here in the locally, thereby certain treatment has been going on from 2022 onwards. Now, the petitioner's plea out here were that the petitioner were not provided the records, one. Secondly, the petitioner seeks an inquiry in respect to certain negligence committed on behalf of the hospital. On the last occasion, I passed an order directing both the Christian Medical College Hospital as well as the state government to provide the names of 2 persons. One is a pediatric pulmonologist and a pediatric neurologist who can, after digging into documents and after looking into the baby, can provide an inquiry report as to whether there was any medical negligence, one. And secondly, what is the what steps are required to be taken for a good prognosis of the child?
Please, my lord.
So these are the two things which are required, for which I had the matter, and I have also requested the Advocate General to help this court.
Yes.
So how we can deal with the situation, more so taking into account that since 2022, the Christian Medical Hospital is also taking care of the child for the last 3.5 years, 3 years, on the basis of orders being passed by this court. At the end of the day, it is actually they are not a state, strictly speaking,
Please, my lord.
but they are still doing certain public service for which, and more particularly taking into account the judgment in the case of Mulchan Hospital, the Supreme Court had observed. There can be something, but at the end of the day, they also cannot be allowed to carry on the treatment if the state is in a position to provide the treatment. So that is the aspect on which I request you to come help.
Please, my lord.
It should not be taken as an adversarial form of litigation.
Not at all. It's a human problem.
How can the baby be helped is the question.
Right. We got a communication just about half an hour back
Yes.
from our department. Our additional AG will just forward it to your lordships, where they're given the names of 3 pediatricians, but one is a junior neurologist, and another person is on respiratory, and the other is the chief medical officer. They're very close to the requirements. May not be a perfect requirement. This is what they have, and we just received it about half an hour back. So if your lordship feels, I feel that let them come and explain what could be done in the matter. Because if they can treat this child or how it can be done, let them have a look at it. This is the closest to which we can get it. In fact, they were also taking a little extra time. So we've been following it up from morning.
Neurologist, the other is a respiratory medicine.
Respiratory, the other is the main person, though his what he specializes is not given. But they are in fact pediatric pulmonologists, neurologists, and they are given Maneshan Konyak, neurologist junior, Kezalunia, respiratory medicine, and other persons, Wapang Inchen, very close to that, pediatrics again. So maybe it may be proper, my lord. Either they.
So, Mr. Advocate General,
my lord,
we can set out a commission of inquiry.
Please, my lord.
Of these 3 persons.
Very well.
Thereby endowing them with certain powers.
Please, my lord.
And giving the petitioners who are in person also an opportunity to place their case as regards ailment of the child.
Very well.
And as well as the Christian Medical Hospital, their person can also submit the necessary details.
Please.
Thereupon to submit a report before this court on these 2 aspects.
That's right.
One
Very
is
relevant.
on the question of negligence, and the other is the question of how we can deal with the baby.
Please.
How treatment can be given to the baby, and what are the best treatment possible.
Please.
And with these things, as I did you read my judgment?
Yes, Your Honor.
This is similar to something like that. So let us first get these things.
Your Honor, if I may just say one thing quickly.
Yes.
These 3 doctors, none of them are pediatric pulmonologists or neurologists.
No.
So they don't have the qualifications.
These don't have the pediatric neurologists and
No.
pediatric pulmonologists in
see,
Nagaland.
But her condition requires such specialists. A normal pediatric has not studied that the brain, they cannot even the pediatricians, they cannot even interpret the MRI scans. So only these specialists can actually know exactly what her condition, what is available for the future. You know, a normal pediatrician cannot. That they never got training in that. They didn't study years and years of the brain, years and years of the lungs, specifically for children, because children and adult is completely different because children's body is continuously changing, continuously growing. So it's really good, if they're gonna do an expert opinion, then they need to be expert in that specific field.
No, this is a commission of inquiry in respect to whether there is a question of any negligence. One.
But they won't understand the brain things.
Then where do we get somebody? We are in Nagaland. How do you take care of that situation? Tell me. First of all, the child is here in Dimapur. You would not get anybody. You have to get somebody out from somewhere. Do you have any names or any suggestions? Because the problem I also face while dealing with that other matter, if you find, initially appointed 1, 2, and all, they keep on changing because they have a lot of difficulties. They are also, because having a commission of inquiry is also a very difficult thing because they will have to hear both sides and then submit a report as regards first is the question of negligence. The second is what is the prognosis? How can you deal with the baby so that the baby will have a proper life? These are the two aspects which are to be looked into. In the you are also at liberty to get hold of anybody, any medical opinion from anybody and give it to them. These are, after all, doctors who are specialized in respiratory medicines. He's a senior specialist and the other is a neurologist. Now, if you have a pediatric, you want an opinion, take an opinion from a pediatric, provide it before this commission of inquiry so that they can also look into it. You want to give evidence of those persons before them. Very well. You give it those persons out there. But the fact remains that they are to decide as to whether these two things. You give any opinion. Why you find out, you go to Gauhati. Gauhati also has some pediatric neurologists and yes, I think there was in my judgment out there was a pediatric neurologist, no? Have you looked into that?
Maybe now?
No. In the judgment I have referred to.
Oh, yes.
There was a pediatric neurologist and also a pediatric so-and-so. Where is the judgment? Anybody has taken out? No. You have a copy of it?
We don't have the copy, but we have the
that day I took it out, 2024 3 PLR page 16.
Your Honor, the only issue is that that's like asking a washing machine mechanic to check your vehicle. Those are two completely different fields. Even the MRI scans which we've had done on the baby, none of the doctors here can interpret it. Even the adult, we went to the adult neurologist in Faith Hospital. He also told us that no, these are two completely different fields. We won't be able to interpret that. You need a pediatric neurologist. So if these doctors are not in that specific field, how can they come to a proper conclusion of whether there was negligence or not when they don't understand the actual?
So therefore, I'm giving you the opportunity to provide medical evidence.
Okay. But we will require time to approach.
They will be issuing notice to you.
Okay.
And when they issue a notice to you, then you produce the medical evidence. You get held of an opinion from a pediatric neurologist who can understand the MRI and explain it to them. That look here, this is the state of affairs. And thereupon, they will look into it.
Okay.
And whether the report is to be accepted or not, again, he will come back to me. But we want a final opinion as to what is the best prognosis.
Yes.
How can we deal with the baby? That is the most important aspect.
That also will have to be from the actual specialist, the pediatric pulmonologist and pediatric neurologist.
So where is your opinion? Tell me, how do I help you? Like you are also may not be knowing much into this medical science. I also don't know.
Yes.
I am only a person who has done my LLB and all. So I don't know much on this aspect. Neither any of us would know how it is to be dealt with, whether these are properly done or not. We are not in a position to do it. Now, therefore, the question is, there are two options. Therefore, we can also do one thing. without going into the question of negligence, if you want to go before the consumer forum, you can go.
Yes.
You can go, and that is what on the last date I have passed an order to the effect. Where's that I-65, that order, 58 order?
And that, my lord, is the correct remedy, what your lordship has just said. In spite of that, my lord has taken the burden of trying to see if something can be done. So when that is being done, no obstacles should be put. Everybody should cooperate.
The petitioners in person also submitted that insofar as negligence aspect is concerned, they would also like to approach the consumer dispute redressal forum as there has been a continuing wrong committed by the respondent number 1 along with his doctors. This aspect this court shall consider while dealing with the writ petition wherein certain directions have been passed separately today. So I have kept that alive, which you mentioned on the last date, if you remember.
Yes, Your Honor.
That you may want to. Now, therefore, there are two aspects. If you want to take up the entire aspect of negligence there, you can go ahead. Go ahead and prove it before a consumer. But the problem again remains. The consumer court also doesn't know anything.
Yes.
There are also judges who are retired judges, as well as those, maybe some medical officer may be there as one of the members. But at the end of the day, they will also not understand unless you give evidence.
Yes.
So therefore, the question is, if you want to go for a commission of inquiry, I can have it. But the other is, as regards the prognosis. For that also, you need an opinion. Somewhere, some opinion has to be given. Where do I get this opinion from?
Yes, Your Honor.
You give me an idea.
And we will do that. We will approach the experts.
So give me an opinion how it is doing. Because AIMS have categorically 4-person panels, experts have said that the treatment which is being given is the only treatment which can be given, nothing more than that. That is what AIMS have stated in that letter dated 18/4/2022.
Yes, Your Honor.
So therefore, if that is so, now the question arises is, we have to also ask the state to take what can be done. That is why I have requested the Advocate General to give me a suggestion.
I think your lordship's views are perfectly right, but they also need to cooperate and they should keep in mind that in a writ petition, normally evidence is not really entertained in detail. In spite of that, this honorable court is trying to find out some short method by which we can club things together and come to a conclusion. When we are coming to that point, they cannot say, I want this and I want that. If they are not satisfied with this, then we will say, what is the next alternative? Let us make a beginning.
Because you see, yes, Mr. Advocate General, the problem which arises is this court has very less limited, have a lot of limitations. I don't know what actually is happening.
Yes, Your Honor.
Neither you can also say what actually is happening. You cannot also, but one thing I know that on 18/4/2022, there is a document which says that the treatment which is being given now at that point of time by the Christian Medical College is the only thing and there is no case of rare disease. This is the final opinion which I know. This is the question of fact. Now, if you want to say there are certain more things which can be done and all, because now the question, if that is the treatment which is being provided, and Mr. Abraham, I ask you to provide me what is the treatment given now.
My lord, my junior is coming. He is there. He is there.
This is the cardiologist and one is the seizure.
So kind of you.
Have you given it in a more simple language?
Very simple. Very simple. Very simple.
Now, the question is whether this treatment can be given in the state hospital by the state of Nagaland.
Lordship, my AG.
The AG doesn't have that document, so that is the question. Mr. Advocate General, the question therefore is with the treatment plan which has been provided by the Christian Medical Hospital,
Prisoner.
is as to whether that treatment can be provided by the state of Nagaland, means whether they have the facilities for that. And it seems
Prisoner.
from what it is being given, there
Yeah.
seems to be nothing, no rocket science about the
No,
treatment. which
no,
is given.
not at all.
It appears to be the simple ventilator thing, along with certain drugs which are being given as regards neuro disability and tube feeding gastroenteritis, and there's nothing. Others are not a issue. And respiratory lungs, long-term ventilation is the issue out here. And what is required is oxygen minimal during the day and minimal ventilator, breathing support at night, nasal tube feeding and medication, care of her breathing tube on the neck. Now, Mr. Advocate General, we give you these details and
We'll also look into
you come back to this course whenever it's you can
I'll- please.
so that we can take a call what can be done.
Prisoner.
And we would also request the state to have a discussion with the Christian Medical College.
Please, please.
How to deal with the situation.
Yes,
Yes,
my lord.
I think that is the way out. And give the, if the petitioner is not inclined to go for a commission of inquiries, taking into account that we have to give the petitioner the liberty to go for a proceedings in before the Consumer Dispute Forum.
Please, please.
We give you the liberty.
Yes, my lord.
Keep the matter pending as regards the child. The child, what can be done for the child? That will keep the matter pending. Only as regards that, which will be the prayer number B again. Now, therefore, the question is here, if you want to go to the consumer forum, you can go.
Yes.
Now, this, the commission of inquiry, they say this can be done with these three persons. Now, if you have a problem with that because they may not know if you think so, then the only way out, if you see the judgment in Jacob Matthews and all, you have to give medical evidence and proceed with that before them. Now, do you have those documents on the basis of which you can file the case? Because your prayer number A is that you want those documents. Do you have the documents now?
We have the documents up until April of this year.
It's okay. That is.
We don't have
that is-
anything
that is
after
enough.
they're withholding. They've done
No,
procedures without our knowledge or consent.
No,
They're withholding.
madam, that is enough for you to file the case.
Yes,
Because
yes,
your case is actually during the time of birth. You see, the negligence as per you occurred at the time of birth.
For the first,
So therefore,
Yeah,
do you
yes.
have those documents I'm asking? You have
Yes,
those documents.
we have
So
them.
therefore, your prayer number A is already taken care of.
okay,
Now, prayer number B is in respect to you want to go for a inquiry.
yes,
An inquiry should be appointed. Now, the inquiry which this court is in a position to appoint is those persons which they have given. Now,
okay,
if you are not inclined that they are not going to give you a proper thing, the only way out is to you have to get an opinion. I'm just advising you,
yes,
although it is not my duty to do so.
yes,
You have to get an opinion from a medical expert on the basis of the materials which you are having
yes,
as to whether there is a negligence. Get that opinion. Then on the basis of which you have to approach the consumer forum. It will depend on what is your claim. A claim which is around, what is that nowadays, 20 lakhs or 1 crore? It is before the district forum. If it is more than that, it goes to the state forum, and if it is more than
It
20.
is state forum.
Huh?
It is from the state commission, my lord. More than 1 crore, it will go to State Consumer Dispute Redressal Commission. Nagaland.
Actually, there was an amendment done to the.
No, that you look into it.
Yeah.
Actually, we don't deal with that. But I'm saying from my experience when we were doing the law.
Yes.
So it will depend on your claim. If your claim is within a particular limit, then you are to do it on the basis of you have to go to the district consumer. If it goes to from there to another limit, you have to go before the state consumer forum. And if it goes beyond that, you can go before the national consumer forum. These are the 3 levels on which you can go.
Yes, yeah.
So that is your thing. Now, again, for district consumer forum, you will have a district judge along with another 2 members looking into it. State consumer forum, you normally have a high court judge along with 2 members looking, of which all these members, one of the members happens to be from the medical field.
Yes.
And the National Consumer Forum, you have a retired Supreme Court judge who looks at it. So this is your scope.
Yes, yeah.
Now tell me, what do you want?
We,
however, think we will keep the matter for how to deal with the child in question as regards the treatment or not, we keep the matter pending. But as regards the A and B, the moment, and again repeating, if B goes, D immediately goes.
Yes.
D, if it goes, D also goes. Then it is a case of compensation where it will go there.
Yes.
So therefore, you have to, I hope you have understood, I have explained.
Yes, I understand.
Yes.
Yeah.
And the genealogy of the case, my lord, with respect, in the present case, it unfortunately starts with a natural calamity. Then whatever happened, it is not attributable to anybody. Unfortunately, it happened. So it's after that they have come to the hospital. There is one fact also which they should keep in mind. And they should also keep in mind, like what your lordship has said, that the premier body like AIMS, they have confirmed that the system of treatment is correct. What is going on? So in spite of that, if they are able to vary it, let them give it.
Mr.
No
Advocate,
problem.
here in this case, I am also a judge, I am also an amicus also. Because of the fact that there is no lawyer who is helping them out.
We will put our inputs. Once they give their report, we
Ah.
will examine it. Let them give us sufficient time to go through it. I'll make it up to date. I'll have thorough study of it and then leave it to them. If they feel that something else is better,
No,
then
the question of if they are not willing to go for the commission of inquiries, we close prayer number B.
Correct.
With prayer number B goes, D goes.
Correct.
EF remains, which I ask you to talk it out with the Christian Medical College, how E and F can be dealt with. But however, one thing, I cannot also lift out the treatment. Give me some suggestion, how can I do so? Because after this, it is a court.
very, very gracious views, my lord, taken into consideration that a helpless child is being looked into through the court.
Because for me to take out
Right.
ventilator would be very difficult. It's not possible. I understand Mr. Abraham has said about the question of sympathy. It is not the question of sympathy. Yeah, like day before yesterday, the Chief Justice of India said that human dignity is also a constitutional ethos.
Right.
Yes.
Your Honor,
My lord, I have a special prayer, my lord.
Yes.
My lord, I have a special prayer.
Yes, please.
For the interest of the case and the interest of the child and interest of all parties, my lordship has to continue inquiring this case wherever, even he is in the main bench of Gauhati High Court. Wherever my lordship is there, he can continue, please, as a very special case.
I understood, but I had a big. I've spent a lot of midnight oils in taking up another matter, which I have, as I said, this was a case which reported judgment. It was a very difficult judgment. It took me a long time to come up and give something out there and how it is to be done. And I have given you see the relief which I gave and asked the social welfare department of the state and these,
This, my lord,
yes.
different lordships, is going on, is prolonging more than 5 years now after filing the writ petition. If my lordship is there, he understands very clearly and disposes quickly also. It is good for all the parties as well as for the child.
Yes, no, that.
May I please request that?
No, therefore, Mr. Abraham, I have requested.
I am obliged. I am very much obliged if it is taken.
Mr. Abraham, therefore, I had requested the Advocate General's presence, and he is present because of.
Grace, yes, grace, yes, yeah.
Yes, what do you want?
Your Honor, so our only options is either inquiry here or to do it in the consumer. Only one or the other, right?
Because it makes no sense, nah?
Yes, of course.
So you have to have an inquiry, but we keep the matter as regards the child. I'm keeping it.
Yes.
What can be done? I'm keeping it. The lawyers out here is saying that I should keep it with me.
Yes.
Because not to give it to other. I have looked into this matter properly, so they are asking me to keep it. But again, these are very difficult matters. These are not simple matters where you don't require anything else. So means in other matters you must have seen while I was doing the matter, we have nothing, no sympathy, nothing out here when we do it. But this is another case where we are concerned with the child. On the basis of protective orders passed by this court, the child is still alive.
Yes,
So we cannot also think about pulling out this, the life support. So this is why this is a very sensitive matter. So they are saying that I should keep it with me so that I deal with the matter. Yes. Now tell me, what about B and D? B, the moment I'm explaining it, B goes, D goes. EF remains, which I'll ask the Advocate General to have a word with the Christian Medical College and they will deal with it. That will be done. Now, if B goes, D goes. Now, if you want to go to the consumer, I kept that day you said I recorded it in my order. So if you want to go to the consumer, I take out B.
Okay.
Because you cannot have parallel proceedings.
Yeah, sure.
You cannot have parallel here, there, you cannot. So I'm asking you, what do you say on that?
Then, Your Honor, we would like to go to the consumer.
You go to consumer.
Yes, Your Honor.
Okay. Then this aspect is being taken care of. So therefore, the question is, once B goes, D and E and F, D also goes.
Yes, Your Honor.
Okay. When D goes, E and F remains, which I will request the Advocate General to have a word with these people, with the Christian Medical College, and how to deal with it. We'll look into that. Now, as regards the child's thing, thing is, this is the treatment which is being provided, as your Additional Advocate General has been given a copy. When it would be convenient for you to both of you to come back again to give me what can be done with this treatment, so that we cannot keep on asking the Christian Medical. It is after all a mission hospital to continue to give the treatment. So how is it possible? So think about it, Mr. Advocate General, and come up with a solution. And I know you will come up with a very good solution.
Even in 2006, my lord, when the Christian Medical College was to be instituted, I appeared for the government.
Yes.
Because there was a lot of opposition that they should not be given by various interested elements. Then I told the Honorable Court that time, if at all you have a heart problem in Nagaland, nobody can say. Immediately put the file and said, take it. That is how this was instituted.
Yeah.
And it's doing quite well. Hospital is doing quite well.
And Mr. Abraham, I'll also ask upon you to, you may be looking into the baby, but take it as also you are a mission hospital. Mr. Abraham.
Yes, my lord, it's a mission hospital.
You are a mission
Completely
hospital, and I'm trying to help you out, but you also have to come down to what you have stated that day. You cannot keep on insisting when the state is involved. Okay, then what do you say, Mr. Advocate General? Should I keep the matter with me?
I think that is more advisable.
Hmm?
I don't think anybody will have so much time to, because it is legal angle and the human angle. And it is a case like something like what Lord Denning used to take up. Human angle is there.
Then you can do one thing. Whenever I am not here, so I will be there in Gauhati. So when I'm in Gauhati, you can appear through the video conferencing.
No problem.
You can appear from a video conferencing mode from here, there, or any of the courts, they appear. So on the date you will be intimated. I always fix a date or at the time. So on that date, you appear and they will provide the video conferencing link to you so that you can appear when I'm appearing. I'm sitting in the principal seat. Okay?
Yes, Your Honor.
My lordship is gracious.
Yes.
Much obliged, my lordship.
I'll pass an order.
Your Honor, if I may, IA 114.
Yes, what is that?
The court ordered us to amend the course title. So we've done that. Actually, the court said until we amend the course title. After amending the course title, then the court will listen. So we've amended the course title now.
What is 114? One four is some harassment, suppression of records, false allegations, and all these things. Direction, installation of CCTV camera, and all this.
Yes, Your Honor, they have implemented a restriction on visitation rights. So, as we stated, last hearing, Your Honor asked about our occupation, no? And since the baby was born, until this incident happened, where they falsely accused us of physical abuse, which, by the way, they still haven't provided the CCTV to the police or to the court. I mean, there's...
Madam, that is an aspect which you alleged before the consumer forum.
Well, Your Honor, visiting hours, Your Honor. We have been able to visit our baby. It's common practice all over India. The head of the department, he also checked.
I could see that you have been only able to visit.
No, that's not true, Your Honor.
21 visits in 56 days.
If they provide you the CCTV at the door, you will see. Is if we don't come at a specific time, like for example, last week, we had a tire blast on the way there, so we were 2 minutes late. So they don't allow entry. But we come every day to the hospital. Of course, if it's not the exact time, then we're not allowed inside, but we do come to provide the baby's food, to provide her clean clothes. Every day we wash and dry and bring the clothes every single day, 7 days a week. The CCTV can show that. She's never missing anything, any food, diapers, nothing. We come every day. Last week we had some car issues and we did call them and told them.
So at what time do you go there?
We can go either at 9 a.m. or at 3 p.m.
So
But when my husband is doing daily wage.
But madam, the visitation hours is given for a 1 hour or 2 hours?
30 minutes. 30 minutes, Your Honor.
Okay. So, okay.
Up until, from her birth.
I'll ask Mr. Abraham,
Yes.
he will take care of it, don't worry.
Your Honor,
Anything
I
more?
think they should
we've,
keep on.
we're not able to go inside and see our baby. They also have implemented a very strict once in a year, allowing us to even take a memory of our baby, a photo of our baby. Only on on her birthdays can we take one photo of our baby. Like, we don't have any memories. Her condition is such that only God knows when she will pass. We have no memories of her. 2025, we have 0 photographs of her. 2024, only on the 7th of November. 2023, same on the 7th of November. They say that, oh, privacy issues. How is privacy issues? Is my baby, there's no privacy issues. They have CCTV. Also, the nurses have taken photos of my baby and shared it amongst their WhatsApp. I've spoken to the head of department about it and asked him whether he knew that was happening. He said yes. So I told him, don't you think that's unfair? The staff is taking photos of my baby and sharing it on WhatsApp, but at the same time, you're telling me that I cannot take a memory of my child, which has been there in the hospital for almost 5 years. She's going to be 5 in November. Like, it's extremely unreasonable.
Okay, I'll take care of it. Wait.
Hey.
Heard Mr.
May I submit?
Yes, please.
My lordship knows that giving a treatment to a patient is a contract and the privity of contract is there. So we cannot take photograph or TV or camera, etc., for a particular patient. And tomorrow in future, she may also file a defamation case against us with all these things. And normally, we will not give any records or camera, etc. We are not using for the patient. It may reach to the third person's hands. So
No,
at that time, as per the principles of contract, we are not allowed actually.
Mr.
Another aspect.
Mr. Abraham, listen. You say, we are looking into this. Okay, as regards photograph is okay, but give her visitation. She goes every day.
Yes.
Give her some particular period where she will visit. Okay.
Sure. Yes, my
We
lord.
will look
We will do
into
it.
this.
Sure.
We will see how it can be done.
Much obliged.
Later on the next date.
Sure.
Okay. Thank you, Honor.
Yes. Mrs. Barbara Nunes as well as Mr. So-and-so, who are the petitioners in the present case, are present during the course of the hearing. This court had requested Mr. So-and-so, Mr. K.G. Balagopal, the learned Advocate General, to assist this court so that the matter can be resolved. And the learned Advocate General have duly agreed to assist this court in that regard. This court have also heard Mr. V. Sukre, the learned additional AG, as well as Mr. S. Abraham, the learned counsel who appears on behalf of the respondent number 1. This court had passed an order on 1/9/2025 in the writ petition, whereby the respondent number 1 was directed to provide the treatment plan of the child of the petitioners and what is the health condition of the child of the petitioner presently. Mr. S. Abraham, during the course of the hearing, placed before this court the current situation of the petitioner's child, as well as details have been provided as to what treatment have been given to the child of the petitioner. The said aspect, the said communication so placed is the said details so placed in the form of a communication, in the form of a report signed by the senior consultant PD, MD in pediatrics is kept on record and marked with the letter X. The registry is directed to prepare a separate file in respect to this document. In addition to that, Mr. Abraham also placed before this court the Caesar record chart of the child of the petitioner. The same is kept on record and marked with the letter X1. Pursuant to the order passed by this court on 1/9/2025 in the writ petition, details have been submitted of an instruction issued to the Additional Advocate General by the Principal Director, Health and Family Welfare Department, dated 4/9/2025, have been placed. The said communication is kept on record and marked with the letter Y. From a perusal of the said communication, it reveals that reveals the names of 3 specialists who can carry out an inquiry in respect to the details as mentioned in paragraph number 9(6) of the order dated 1/9/2025. The petitioners in persons have also been provided with the communication dated 4/9/2025. The petitioner in person submits that the person's names which have been provided are not specialists in respect to pediatric, are not specialists, are not pediatric specialists in the assigned pediatric specialist, but rather they are specialists in respect to
urology,
adults.
Yeah.
Full stop. The petitioner in person further submit that instead of going for an inquiry, they would instead obtain medical opinion from the concerned specialist, and if the opinion is in their favor, they would approach before the consumer redressal forum, before the redressal forum under the Consumer Protection Act 2019. The petitioner in persons therefore submitted that they would therefore not insist on prayer number B, and submitted that the welfare of the child is the prime consideration. Taking into account the above, the prayer made at the prayer number B stands withdrawn. The consequential effect of the prayer number B being withdrawn is that there cannot be any directions passed in respect to prayer number D, for which the prayer number D stands closed. Next. This court have also perused prayer number E and prayer number F. This court would request the learned Advocate General, State of Nagaland, to take a call on what can be done in respect to the resolution, in respect to the prayer number E and F. Mr. S. Abraham, the learned counsel who appears on behalf of the respondent number 1, submitted that the respondent number 1 is not adverse to talking with the state for the resolution of prayer number E and F in discussion with the state as regards prayer number E and F. Full stop. This court further takes note of that a copy of the document which have been kept on record and marked with the letter X have been furnished to Ms. V. Sukroy, the learned Additional Advocate General, Assam, Nagaland. First, this court would request the learned Advocate General to implore upon as to whether the treatment plan so provided can be provided by the state of Nagaland in respect to the child of the petitioner, taking into account that the treatment plan so provided is not, it does not appear to be too complicated. Full stop. Too complicated, as submitted by Mr. S. Abraham. Full stop. This court further inquired with the petitioner in persons as to whether they have documents in respect to as to whether they have the medical records in respect to the child in question. They submitted that they have the medical records of the child in question up till April 2025. Full stop. In that view of the matter, the prayer number B, that is prayer number C, C has become, she would withdraw C, not B. That is C, and C and D has become useless, as I said, but it is C, not B. Earlier when I was saying B. Therefore, the prayer at serial number B appears to have been already. Relief as sought for at prayer number B appears to have already been redressed up till April 2025. First, the petitioner in view of the above analyzed discussions, in view of the discussion and in view of the above, therefore, the only thing which remains before this court in the present proceedings is to what treatment can be given for the child, what and how the treatment can be given to the child of the petitioners. Full stop. The petitioner in persons as well as the respondents, as well as the respondents as well as the learned counsels, learned advocate general, as well as the counsels appearing on behalf of the respondents, had submitted that as the instant matter have been heard in detail by this court, the instant matter be kept as parted. As more particularly, there would be a requirement of a regular monitoring. Full stop. Taking into account the above, comma, the instant proceedings be shown as parted. Full stop. The petitioner in persons submitted that they are facing difficulties in visiting the baby or their child in the hospital. Full stop. Mr. Abraham, the learned counsel appearing on behalf of the respondent number 1, submits that taking into account that various cases have been filed, the respondent number 1 is have to maintain certain what have to maintain certain
Quorum.
huh?
Decorum.
certain protocols.
Professional decorum.
A certain protocol, professional
It is
protocol.
meant for both the parties.
Certain professional protocol. Full stop. Here was submitted that during the visitation, as the child of the petitioners is in the ICU, no? And the visitation hours being from 9 to 9:30.
9 to 9:30 or 3 to 3:30.
3 to 3:30. And the same being applicable for all concerned, the respondents have adopted the same practice. Full stop. This court would request Mr. S. Abraham, the learned counsel, appearing on behalf of the respondent number 1, to ask the respondents number 1, ask the authorities of the respondent number 1 to give certain to provide some adequate opportunity if for reasons beyond the control of the petitioners, they are not in a position to visit. However, the same should be done, keeping the interest of the other patients also. When should we have it, Mr. Abraham and Mr. Advocate General? When should we have it?
Maybe after 4 weeks or 6 weeks. And maybe it may be proper, since she has got the records from the beginning till April 2025. That is also made available to our doctors. Because it will give a background of what exactly it is.
And Mr. Abraham, we also ask you to give a copy of these records to you give the records to Ms. Ukraine. So that can be played before they will also know what is to be done.
Yes, Lord.
Gusto.
I'll do that.
This court would also direct the respondent number 1 to provide the medical records of the child of the petitioners to Ms. we supervise the learned additional advocate general so that the same be provided to the health department of the government of Nagaland, health and family department of the government of Nagaland. Full stop. Full stop. The said records be provided by within a week's time. Full stop. List this matter again on 23rd of September 2025. Could it be possible, man? I think
My lord, could it be in October, my lord, after the puja?
no, 23rd is the last week. Then we are on vacation. No.
Okay.
Before vacation.
Sure.
23rd of September 2025 at 2 p.m. The
Very
raise
good.
of this court is directed to provide video 2 p.m. Full stop. As this court will be taking up the proceedings from the principal seat of the Gauhati High Court, the registry is directed to provide video conferencing facilities to the petitioner in persons on petitioner in person for them to represent themselves.
Thank you.
Yes.
Much obliged, my lord.
Mr. Advocate General, first and foremost, I forgot. It's a Onam today.
Yes, it is Onam.
And I have restrained you. I will wish you a good Onam.
Very grateful, my lord. We wish you also a wonderful honor.
Yes.
Also to Mr. Abraham, since I think he's also from Kerala.
Yes.
Kerala, all the communities celebrated.
Both of you.
And to everyone else in the court.
I am from Madras.
Oh, you are
Okay,
from Madras.
Anyway, it doesn't make a difference. Madras and Kerala, we celebrate things together.
Yeah. Yes.